Now back to the show. This is The Law Show on CL 650.
Here I am, stuck in the middle with you. Yes, I'm stuck in the middle with you.
Yes, you're listening to The Law Show on CL 650. Today we're speaking with family lawyer David Halkett and partner at McQuarrieHunter, and Sarah Morris is an associate at McQuarrieHunter, right in, did you call it Surrey Central? Is that right?
Yeah, Surrey Central.
Surrey Central.
It's also known as Downtown Surrey.
Downtown Surrey.
Yep.
Good to know. Now, one question I have is because I have some neighbors of mine who are lawyers, and when it comes to a breakup of a relationship or a divorce, in the eyes of the law in British Columbia, there's no fault placed on somebody. So if somebody fools around and gets caught and then you break up, so just because the relationship's coming to an end because somebody did something bad, you don't get extra for that, right?
No, you don't. Now, potentially that there is some law that says that if you're so devastated by it, you can get more spousal support. But in terms of assets, no, the assets are divided as they are.
All right, good to know. Now, let's go through that process, because when someone comes in, obviously the biggest thing is children, which we're not talking about on this show, but money and assets, right?
Exactly.
So you need that comprehensive list of your assets and what you have together, right?
Yep.
And this goes for people who are married and also common law. So before we go into the list, where does common law start in British Columbia?
We just changed the law in 2013 when the new Family Law Act came in.
And this is a federal law?
Provincial.
Provincial, okay.
Yeah. The federal act, the Divorce Act, only deals with spousal support, child support, and access, custody, and breakdown of the marriage. In the provincial statute, which is the Family Law Act, it deals with everything except for divorce. Okay. So it includes division of assets. And it states that you are entitled to divide your assets if you're legally married, or if you live together in a marriage-like relationship for at least 2 years. So that was new in 2013. Before, you couldn't divide your assets as a non-married couple except through old trust actions.
So does that define by one house? Like if you're dating and you have two separate apartments, for example, are you common law after 2 years if you've been dating? So what's the line there?
You have to have lived together in a marriage-like relationship. Now, you don't have to actually be physically...
But you might be at somebody's house 99% of the time, and the other apartment's empty, right?
That's what our arguments are.
Yeah.
It's absolutely an argument, and you have to look at all the situation itself to determine whether it is, in fact, a marriage-like relationship.
Yeah, and there are a lot more people do live together now, and so than when I started law. And so you do have to look at the whole aspects of the relationship. So say, for example, you were living with someone, Zach, but then you went to work in Toronto for 8 months. You still may be deemed to be living together, even though you were separated, because the geographic distance isn't necessarily the determining factor as to whether or not
it's emotional, right?
Exactly. Yeah. And there has to be a physical separation and an emotional. But if you still thought you were together and living together, you just were working away here. We have a lot in our cases. Someone's gone up to Fort McMurray.
I was going to say that. Yeah, the oil patch, right?
Exactly. So they may still be living together. There has to be some kind of dependency between the two individuals. It would seem to me, in a case if they were living in separate residences, usually you have to be living in the same residence.
And that's not very common. I'm sure that people keep two separate addresses, right?
No.
Especially in Vancouver, yeah. It's so expensive.
And then that ends up being the argument when someone says, we were living together. The guy goes, no, I had my own mailing address. Right. All my T4 said this. My government
my
stuff.
parents' basement, right?
Exactly.
Yeah, you can't get around that stuff. Okay, so someone comes into you and they have had that 2-year relationship, or obviously they've been married. And are you starting to see breakups in, gay relationships?
Yeah, I've had some of those. I've had same-sex relationships. And because the law is relatively new in terms of automatic division, I haven't seen as many of those. But and where our office is located, it's not as
prominent.
There's not as many same-sex couples, but certainly we've had a few.
I guess be careful what you ask for, because you might just get it.
Yeah, exactly. Well, that's the thing. They all same-sex couples wanted the right to divide assets until all of a sudden they had to.
Yeah, exactly.
This always is the case.
So, what is it that you ask people to list for you when you're talking about assets?
Okay, so for me personally, I say, okay, what did you bring into the relationship? And Sarah can talk about how the exclusions are, but what did you bring into the relationship? Because that may not be family property. What assets did you get together? List of all your RSPs, pensions, bank accounts. If you have a safety deposit box, what's in that? And you also want a list of debts as well, because debts are divisible at the same time.
Yeah,
that's what I do anyway.
So what things are exempt? Okay, so for example, my parents passed away and I inherited, you know, $500,000, and then you get into a relationship. Can your spouse go after that $500,000?
Well, any property that you yourself accrued prior to the start of the relationship is now actually set out in the family law as excluded property.
Okay.
But what may be divisible is any increase in value of that property from the start of the relationship to the end. So one thing that David and I think is quite important now is for people to have that information available. So for people that are newly getting into common law relationships or marriages, it's really important if you have excluded property to value it when you get together.
People are thinking that they're in love.
Exactly.
We've just got our new apartment and a puppy and all that stuff, right? They don't think about that stuff.
It's emotional. It's not rational, but it is really important if you can to even just print off your property assessment if you have had a property that you owned before you lived with somebody. Throw it in a file. Print off your assessment report. It's good to be able to have that value instead of having to go back and try and figure it out down the road.
Okay, so I'll use that $500,000 inheritance somebody got. They have that $500,000, they get married, and then they decide together to invest that $500,000 into an income property. And over 10, 15 years here in the Lower Mainland, you made a lot of money off of that. So you're saying the lift between the $500,000 to say $1 million, that is
potentially divisible.
That's divisible.
Yeah, but if excluded property is commingled with other assets, I mean, if you start putting that money into one asset and another asset and another asset, it may well lose its excluded nature of it because you can no longer trace it. So the rule is you have to be able to trace that from one thing to another. So if you are bringing excluded money, say an inheritance, into a relationship, then if you're going to buy a boat with it, buy the boat yourself with it to make sure you can see where that money is gone.
There's case law that's making its way through our courts in this province to determine whether or not, if I have an excluded property, so say Sarah and I were together and I have $500,000, using the number you said, Zach, and then we buy a house together and we make it in joint title. Normally I can trace that $500,000 in, but there's still the old law of presumption of gift between spouses who are legally married. One case says, well, I've given Sarah half of it.
Right.
Another case says, no, you still have the exclusion. So our court of appeal, our court of appeal will tell us, hopefully soon, what that answer is. But it is better to either have something in writing, if you can, to say, here's my excluded property, and it's going to remain mine, except we'll divide the growth. Or make sure you don't put it in joint names at this point until we know what the law is, because we're still only 3 years into the new statute. So
it's very unromantic, though, isn't it?
It is.
It is, but to protect yourself early on, as opposed to dealing with a costly court battle, and it's also a conversation that a lot of people probably should have.
You know, when I got married, I had my CD collection, and I'm sticking with it.
That
My wife can have half of it.
Yeah. I was like, well, that's it, right?
When you go in with nothing, you have, everything is divisible.
Well, exactly. The excluded property tends to come in more for second marriages.
Yeah.
Definitely.
And stuff where someone wants to protect for their children from their first marriage. We do have some that come in and say, well, I brought 30,000 of RSPs in the relationship 20 years ago. Well, there's no documentary evidence, and our law says you have to at least be able to prove to the court that you should have the exclusion. Because other than that, they go to the fallback position, which is all property owned by the spouse is divisible. So it's you're right. It's very unromantic to talk about that. And so, I know people are getting married, and I say, well, you should get a prenup. Well, we're not going to get divorced because no one ever thinks you're going to get divorced.
And people look at a prenup as this, I'm protecting, you're never going to get anything from me because one side of the relationship might have quite a few more assets. All you're doing is just listing the status quo, right?
Exactly. And the good thing with an agreement, a prenup or a cohab is you can set out what you had going in. So it's evidence later the other person acknowledged it.
So what you're not saying that you're not going to get anything. You're just saying these are the assets we have separately to bring together, right?
Exactly. And then how you word it, you can say, I'm going to keep this, depending on how long we're together, or we're going to divide however. You've just set out exactly what you had, which makes it simpler.
Yeah, and there's clients that will actually structure it in certain ways. The longer we're together, the more of a greater percentage you're going to get. So there's ways to customize it so it doesn't have that sense of unfairness. It's protecting both parties. So part of it is how you frame it, I think, in having that conversation.
It doesn't have to be the Tom Cruise, Nicole Kidman prenup where if they were together 10 years, she got half of everything, so he kicked her out at 9.5 years, that kind of thing.
Did that really happen?
Yeah, apparently that's the law in California.
That is very unromantic.
It is.
It is. Okay, so what if it's lopsided? Like one side makes a lot more money than the other person. It doesn't. The court doesn't really care about that. They just know that you're coming together. So you have a CEO of a company makes $300,000 a year, and then you have somebody who's maybe the receptionist that he met at work, and she makes $50,000 a year. Who knows, right? Could be the other way around. So when they get married, doesn't matter.
No, the court can look at if it's something you acquired during the relationship, and you put all the money in. They can say they find it significantly unfair to divide it equally. But normally the court does not look at who contributed what. They figure you were at a joint venture, you were together. It's a business decision between you, or a relationship decision, and it's just divided.
And then it gets more complicated if you have a business together, right?
Definitely. I mean, then you're looking at valuation and contribution, and it just gets messy.
It does, yeah. Family law can be very interesting when it comes to valuations and all that, right? And then we have the emotional level on top of it. So,
well, when we come back, I want to talk a bit about. And we're not going to focus on children, but we want to talk about like the parenting plan you have for kids and the amount of money. And the other thing I want to ask you about is when you actually get to the point where you're coming to see you and you're maybe living in the same house and you have children, like how do you stick handle all of that through the process? Because it's expensive in Vancouver. It just seems to be getting more and more expensive. So when someone comes to the end of a relationship, like what are we going to do? And we have to live maybe together to get through it. So I don't know. We're going to ask those questions when we come back. We're talking about family law. We have David Halkett from McQuarrieHunter and Sarah Morse, an associate there at McQuarrieHunter as well in Surrey. This is The Law Show, and we'll pick it up next here on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.